Hi, everyone. Harry here to talk about the dismissal of the most serious charge against Luigi Mangione, the young man alleged to have, with pretty good evidence, shot and killed the CEO of UnitedHealthcare in a really harrowing, terrible crime right outside the Hilton Hotel in Midtown Manhattan. All right. A very quick point that dovetails with what I was saying about the Kirk case is that this guy may have tried to elude capture. He wasn't caught till Pennsylvania, but it's an example of a good point to understand about federal law enforcement. The cameras are out there, and they're going to be able to put things together from different stores and hotels and the like. And that's how Mangione was found. Okay. But the big point here is they overcharged, basically. And I think this is a kind of good point generally. And in the overall theme we're seeing this week about prosecutors, politics, high-profile cases. All right, so what's going on here? New York doesn't have the death penalty, but it has first-degree murder without possibility of parole. And you can't, as in other states, where in order to get the death penalty, you need a special situation. Same thing here in New York. And the special situation that the district attorney tried to do here, a crime of terrorism. That's the notion. And it's that that the grand jury went for it. The judge here rejected it in a 12-page decision yesterday. And basically, and again, this matters in different kind of sensational crimes around the country. He's saying, look, there is a difference. You go take seriously the definition of terrorism, and it essentially engages the desire to or the goal of terrorizing, frightening a civilian population. The terrorist sort of plan and signature move is to do something that make other people in society think this could have been us, and we're afraid. And they often do it at the service of a political point, but it is really about, as the court kind of explains, trying to harness a broad fear that you instill in the civilian population. And it's that the judge rejected. And when that charge was filed, I said at the time, this is really taking a case that seems open and shut and turning it into one that they could lose. And sure enough, they've lost on this most important point. Who knows how things will play out in the actual trial, but they are now looking at second degree as the highest charge, and actually the possibility that Mangione will one day see the light of day. So here's the judge's analysis at its core. He said the people assert they've established this special intent of intimidating or coercing a civilian population, but there's no evidence presented that he made any demands of government, sought any particular governmental policy change, let alone that he did so by intimidation or coercion. He's got it in for the healthcare industry, it would appear, and he wanted to shoot this guy out of animus toward the healthcare industry or to try to change it. But importantly, that's different from trying to coerce or terrify a civilian population, and that's what you need for terrorism. So it looks as if it was overly done. This has come up in the Kirk case, right? They are looking at could there be a federal crime? There is no federal statute for terrorism. That's been a debate for years. I had supported it. Though I can't say I'm sorry now with the folks in charge at the Department of Justice who are. But a similar kind of notion. Can you show a hate crime? Can you show terrorism? And this is a judge taking it seriously and saying this guy, heinous, directed at the victim for particular reasons, even trying to make a point. But that's just not the same as trying to, be a terrorist as it's defined and as we generally think of it in trying to coerce or intimidate a civilian population. So we now have a situation where the case goes forward. Maybe it even leads to a plea. I don't think that the lawyers who are actually folks who are sometimes fellow commentators, their role here, successful, is a completely separate thing. I don't want to, put them out anywhere. But Karen Agnifilo and her husband, Karen's actually going to be on our podcast roundtable this week. But they argued to the court successfully. It's just not terrorism. They're trying too hard. Okay, that's the ruling. That's where things stand. Let me just mention the federal situation, because this is a case where potentially the feds will sit back, see what happens at the state level, but then try to storm in. And they've already argued, have the attorneys for Mangione in the arguments to the judge that succeeded here, that you should also hold judge that the defendant couldn't be tried on a terrorism charge, which could potentially elevate to the federal death penalty. New York doesn't have it. The feds do, because it would be double jeopardy. And essentially what the judges said, not yet it wouldn't, and maybe not at all. We've been through this before with cases that could go in the state system or the federal system, unlike Kirk, which looks like it has to go for its serious charge in the state system. And there is this funny, strikes some as counterintuitive doctrine that says we are different sovereigns. There's the feds and they're the states. So, if Mangione were tried in pick your country, Algeria, it wouldn't prevent charges here. The same thing. The constitutional bar of double jeopardy doesn't apply, meaning you could see, let's say they go forward and get a result that the feds declare. This is how the policy is supposed to work. Query whether they would actually do it this way, but the policy is supposed to say if the federal interest in this crime, and, there's a federal and a state interest, although it really seems to be largely a state interest. But if the federal interest in this crime is left demonstrably unvindicated, you can come in and try to do something yourself. And so it's a case, there could be a plea. And that could happen kind of quickly, and they might try to button up the federal charges. They probably won't be able to. Otherwise, there'll be a trial, and that's going to be a while. But there's the possibility of a plea, and then will the feds, and it'll still be the Bondi crowd, want to try to get involved, bring their own charges constitutionally, although the Mangione lawyers have already said, you can't do that, and the judge has simply said, I'm not deciding it yet. The black letter doctrine is that they could do it if they decide that the federal interest is demonstrably unvindicated. And a case like this with a high profile, and we already have certain statements, that's, we're learning in the Kirk case and elsewhere, something that the Pam Bondi's Department of Justice might want to come in to without regard to the actual application of the Pettit policy, the name of the policy, and whether things were left demonstrably unvindicated. So we could see this again on the federal level, depending on what happens. I think a conviction for second-degree murder is fairly well assured and may even be the subject of a plea. But efforts to tie it up and keep the feds out of it, that's what's going to be happening down the line. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.